Good evening to you all. A very cordial welcome to our continuing webinar series on IPR conducted by Center of Excellence in Intellectual Property in association with MeitY Startup Hub. I am A.K. Roy from the CoE-IP team, welcoming you to this event. Today, we are privileged to have with us Dr. Mohan Diwan, Principal, Advocate, Patent and Trademark Attorney, R.K. Diwan and Company, and Dr. A.K. Garg, Director, Innovation and IPR Division, MeitY Government of India. The link between knowledge creation and its manifestation through IPR is the hallmark of technology-intensive organizations. And CoE-IP, with its various value-added services over the years, has emerged as a key pillar of support to innovators, R&D organizations, and startups, helping them to identify, protect, and monetize IPs. Today's topic, IPR Lifecycle, Idea to Market, would help us to understand and explore the IP commercialization aspect in detail. Without taking much time, I would now request Dr. A.K. Garg to initiate the proceedings. Sir, please.
Thank you, Anil. It's a privilege to be on this platform, and it's a very, very welcoming initiative by the CoE-IP and MSH. Let me on the onset welcome Dr. Diwan to this very august gathering. It has been a long time after I've seen you, sir. A great pleasure to be here. And we are privileged to have the views of one of the leading stalwarts on IPR, Dr. Diwan, in this gathering, and I'm sure the startup community will benefit a lot from his discourse. So if Dr. Diwan is here, I will not take much time to be in between you and Dr. Diwan. Just will give a context in which I want to hear him on his ideas, that how do we actually look towards IPR in this new paradigm. What we are looking at today is a disruption that is happening in the innovation ecosystem through a battery of more than 50,000 startups in this country. India emerging as the third largest ecosystem, with more than 18,000 of them are in the area of deep technologies, be it AI, ML, IoTs, and all these emerging techs, on which IPR has to play a key enabling role and actually has to rediscover itself according to the new normal. Because how do you define IPRs in an AI world? How does, when data becomes the real value for all these players, how do you monetize data and have rightful protections in terms of IPR? This is all what are the new challenges which the startup world or these deep tech ecosystem plays. The challenge from the topic today is from idea to monetization. So when a beautiful idea comes, it remains with the person who has actually created that idea. But when you are trying to create economic value around this idea, which is the whole purpose of what a startup is, then the whole corporate ecosystem starts getting its act together. And when we all understand that IPR is one of the very key strategies which most of our corporates play, it was not there as the central theme in the Indian ecosystem because we were not in the deep tech space. But when these startups with these 63 unicorns that we have today have brought us into the central fold of deep technologies, so IPRs have now become a key enabling role in our socioeconomic growth. And we need to understand that how can the economic value of idea that I request all to please mute themselves. Thank you. How, when you are monetizing an idea for economic value, how does the rewards of the creator of that idea, the generator of that idea, remains with the person who has actually been the central driving force in this? This might be concentrated in one or two hands, or might be in a distributed models. It might be a combination of technology, data, and business strategies. and how do you differentiate between the three and equally reward on the three aspects? These are some of the key aspects that are of challenge in today's new emerging paradigm in this emerging tech, and we need to understand, and we can have no better expert than Dr. Devan to make you understand on this. One of the other key points that I want to actually highlight in this discussions is that MeitY has played a central role in promoting the deep technology innovation ecosystem, whether that are through its TIDE scheme or whether it is through the next generation incubation scheme, the battery of 29 around center of excellences, and culminating them or bringing them through what we call as a sangam of all these activities is the MeitY Startup Hub, with and that actually has converged all this into this. So now you have one place, one destination where you can look forward to actually address your ideas at startups. The MeitY Startup, under which the CoE-IP also operates and has been there for a long time to provide you with all necessary support, even in terms of financial support under the support for international patents in MeitY scheme. So we have a whole battery of supports that MeitY gives. In addition, the Startup India program has emerged one of the strongest pillars in the last 7 years. And I think this is the right time to be there in the startup space. This is the right time there to create economic value from your disruptive idea. But what are the strategies you need to play if you need to create economic value around your idea? We need to understand this in the next 40-45 minutes of yours. I hope that today's deliberations provide you with a lot of insights into this subject. If you have any further question, do come back to us and we will provide you, we'll try to provide you the solutions for that, whether we have to request Dr. Devan offline to support you, and we are privileged to hear. Dr. Devan, thank you.
Thank you, Dr. Garg.
Thank you, sir, for your encouraging words. Before we ask Dr. Devan to start the proceedings, I would give a bit profile of his stature. Dr. Devan is acknowledged. Dr. Devan is a stalwart in, as sir said, Dr. Devan is a stalwart in the IP arena with over 50 years of experience in IP practice. He is acknowledged as a specialist in patent specification drafting, having drafted and obtained more than 8,000 patents in different technology areas, ranging from life sciences, software, electronics, telecommunications to even space technology. His areas of expertise include patent and trademark litigation, technology transfer, and rights evaluation. Because with IP law practice, Dr. Devan is also an educator, having headed the IP law department at University of Natal, South Africa. So I now request Dr. Devan to address us. Sir, please.
Thank you. Thank you, Dr. Roy and Dr. Garg. It's been nice, and I am indeed, of course, very, very privileged to be on this platform. And firstly, good afternoon to all the participants, and a good day and the rest of the year. And I hope and fervently pray for the success of each one of you in whatever sphere you are, wherever you are, whatever you're doing. And in any way, if I can help during your growth or after that, I'm quite happy. I've seen among let us say of the 60 odd unicorns, I've been privileged to be part of the growth of at least 10 of them. That has been again a great privilege of being with them. And if today I have of course I sent a presentation to Dr. Roy, and I would like that to be shared, but with all of you, and I'm sure the CoE-IP and MeitY will share these with you. But I would today really would like to have a heart-to-heart talk, because I would like you to hear some of what I have to say, my experiences with the startup world, and if you can, I would like you to avoid some of the pitfalls and mistakes that some of the others, out of, let us say, maybe the 60 startups that are 60 plus unicorns that are there were at least, I would say, over 500 to 600 startups that started well. They started up, but faltered, and the reasons why they faltered is what I would like to generally share. Of course, I'm not going to reveal any names either side. I'm not going to reveal the names of the successors. I'm not going to reveal the names of the failures. But they're all there. They're all poignant. And for me, every startup that succeeds is, for me, gives me immense ecstasy. And every startup that fails gives me something that I feel sad about. It feels that why did, and of course I can understand the reasons why they were not able to succeed. There was that question, but the important thing is today's talk will be mainly the 6 I's. 6I, the letter I, 6 words. If these 6 words you can carry forward with you, whatever the time that I'm spending today with you will be worth it. I would like you to take these 6 words with you. The rest of the presentation you can see at your leisure. And if there are any questions, you can ask me, and I'm quite open to ask questions offline. You can call me, you can talk to me. I'm quite happy to do that. So this is and of course, they will share my ID with you if you guys want to write about that. And of course, this presentation was there, but I would like to share 6 I's with you. Before, of course, the idea, there is a place, a source where every idea comes from, and that is your imagination. Ladies and gentlemen, that is the first I. Even before the idea, there is imagination. I think that imagination is your direct connection with the spiritual world or the spirit. That is the area where all ideas take birth. And every idea, whether it is OYO or whether it is the idea relating to Airbnb or any of these Cars 24 or any of the other ideas that have succeeded, and even some ideas that failed, the idea, there was nothing wrong. It was a good concept. It was that kind of energy vibrations that came from the source. I would call that imagination. Imagination is always the future. There are in a point of time, there are 3 areas of time. The 3 areas of time are, of course, the past, which we call memory. That is your memory. That is there. Whatever is in your past is your memory, and you build. Everything is built on that memory that you have. Your brain storehouse, your mind, your consciousness. That is what. That is where your memory is stored. So that is your past. That is gone. That is over. That time is not the time in which you need to succeed. Then there is the future. The future is your imagination. That is the place where you have to look to the future for look and imagine. So that is the first I, which is the important part. And what is today? What is the present? The present is the idea. And that is the only reality, sir. Ladies and gentlemen, if you first aspect of life, and what I've learned to live in the last 70 years of my existence, 71 years to be exact, is that you need to live in the present. You need to live for that idea, which is the present. That idea comes from the imagination, built on your memory, which is the past, and you get that idea in the present. So that is what you need to hold on to, and that is what you need to, that without any fear, that is the area of creativity. There is a balance between fear and creativity. You need to curb your fear and give complete free rein to your creativity, and that is where these ideas are born. Ladies and gentlemen, idea is the starting point of the IPR life cycle. You know, there are different forms of IPRs. There are different forms of IPRs, which we will discuss those different forms of IPR, as probably, I mean, you may have read it, you have heard of it. There is patents, trademarks, copyrights, designs, integrated circuit layouts, and of course a few others like plant varieties and geographical indications, which at this moment we are not really concerned with. But the two areas when it comes to the ICT space particularly are copyrights and patents. And today my talk, I'll focus on these two areas of the IPR life cycle space: copyrights and patents. So when you get the idea, and lots of people, there are a lot of ideas that come. The important part of getting the idea, so the first I is of course imagination, where all this thing arises. Imagination, I believe, is an important, so I would learn to imagine freely. Don't curb, ladies and gentlemen, do not curb your imagination. That is, I believe, one of the major sources of these ideas. And when you get the idea, which is the second I, the important part is to identify. That is the third I, is the identification of what kind of idea is it. Is it an idea that I need to put it out in the world? Is it an idea that is going to become part of my product or process, or is it going to become part of what I need to write a code on? Is it something that I need to share? Do I make a flow chart? Do I make an algorithm? What do I do with that idea? So the identification is the third I. Lots of people, instead of identification, speak of invention. Yes, there may be an invention somewhere lurking in that once you identify that idea. But I have learned to now distinguish or identify that there are certain things that may be inventive. In fact, most ideas have an element of invention. But how do you protect that invention? Whether to protect that invention, what kind of IPR protection is needed, or there is a hidden IPR, which of course, unfortunately in India is not codified, and that is trade secrets. Internationally, there is a trade secret law, and I'm waiting for India, for that in India, we still have, and I believe MeitY can take a role. The CoE-IP, the College of, or the Center for Excellence can also play a role. We need to have what is called a very strong trade secrets law in this country, which is there internationally, and I hope we can all work together in that direction to protect some of your trade secrets, because there are different types of ideas, and some ideas need to be protected by invention, which means take that invention and file patent applications. But the patent process in India, it has accelerated considerably. I've got now patents granted within 12 months to 18 months also in this process. There has been a great, I would say, a catharsis, a metamorphosis of the Indian IP scene. Both trademarks and patents have been now protected by the India, and it is from From an intellectual property neutral territory, we have become an intellectual property positive territory where where the patent office itself has become a good facilitator for good quality inventions, the protection in these inventions. So that is, ladies and gentlemen, the identification of the invention is the third eye. The third eye which we need to look at, identifying the invention. Sometimes you need people like us. We can identify. It is not always sometimes an easy task to identify an invention, and there is a certain amount of expertise that goes into identifying an invention. So please understand that you sometimes need an expert help, the help of an expertise. Just as if you are having a symptom, you need to go to a medical expert to diagnose what that symptom is. You can, of course, put your symptoms nowadays. I've worked with quite a few people in that space on diagnostic tools are available on the net, but you still are more comfortable. Somebody who has a very conscious knowledge about how to identify what is inventive, what is the intellectual property in this particular in this idea that you have, and share it as soon as possible. That is where, unfortunately, several ideas have lost the potential of becoming intellectual property, because the minute those ideas were disclosed, they became what is called public property. They came into the public domain. So remember, even if it is your golden idea, diamond idea, platinum idea, whatever is the idea to be protected for the purposes of monetization, for the purposes of earning revenue, the idea must be converted to an invention, and the invention must be protected as an intellectual property. Particularly if we are talking about patents, we need to protect that. We need to protect that as a patent application has to be filed before disclosure. If just this aspect, I've had issues with even people as far as the government of India enterprises who rushed to publish that particular idea onto the net, who could not wait. I mean, it takes, for example, we have covered ideas into protectable inventions, protected inventions within probably the day. I get calls, for example, at about 3 o'clock or 4 o'clock at night to protect those ideas, into inventions. And by morning we have protected it, because by afternoon 3 o'clock, the inventor, the person who had the idea receiver, it needs to present it to either for monetary purposes, or is holding a press conference, or is disclosing his idea in an exhibition. We need to protect it, and we can protect that idea, but you need to come, you need to tell us, you need to tell one of us. There are a few good IP attorneys in this country, very, very good IP attorneys. And it is important that you share those ideas with them for finding it. It may happen that we may tell you, as in all good conscience, we may tell you, no, sir, no, ladies and gentlemen, or madam or sir, please do not disclose the background of this idea. The front end, of course, you can share with but do not disclose the working of this particular concept, because hold that as a trade secret. As you know, one of the most successful trade secrets was the formula of Coke. It is still very jealously guarded for over a century now. The formula for Coke is very jealously guarded, and they still jealously guard that concept, the exact formula, and no person, no other soft drink manufacturer has been able to replicate that. Had they disclosed that formula in a patent application, within 20 years, that formula would have become would have been sui generis. It would have come in the public domain, and that probably the importance, an important asset, which is called the Coca-Cola concentrate, would have been lost. So they have maintained that a trade secret. So what are called hidden assets? These are your assets. The assets, these assets, sometimes it is important to protect these assets by means of trade secrets. Protect them as a secret. Share with it only on a need to know basis. So that is an important lesson. If I can, and anybody would do, any of you would like to know what to do when. It's important to know the difference, that when to disclose an idea and cover it in a patent application, when to disclose an idea and cover it as a copyright application, when to do a design, and when to hold information back as a trade secret. And how to maintain the trade secret is also an extremely important aspect of the whole exercise, or the entire learning exercise that you will get as a startup, as an entity, as a small, we call them small scale or MSMEs or startups. They go by different names, but eventually, finally, it happens that these ideas can come only to an individual mind. These ideas come from the spiritual world into the mind of an individual, and from the mind it is then translated with the help of memory, with the help of knowledge, with the help of intellect. We call that intellect. I will, at the end, if we have time, I'll share with you what is the difference between intelligence and intellect. A lot of knowledge is of course needed, but that knowledge without the intelligence to use that knowledge is a waste of knowledge. It's just grains of sand in front of the ocean, an ocean of ignorance. So as far as that aspect is concerned, we need to identify, we need to have that level of native intelligence, which each one of you possesses, as part of your world, you're part of your living mechanism. All right. Now, the next I, after invention, once you have done the invention, once you have protected the invention, once you have, or you have understood that it is a trade, that I must keep it as a trade secret, I must keep that as in a secret level, and maintain that secrecy among a few people. Break the invention up into different parts, and on a need to know basis, share it with different aspects of the team. That is also one form of strategy, and some people have succeeded because of that strategy. All right. Now the next part that comes into the next eyes that come into play is innovation. The next I is innovation. Lot of people, there is a great misunderstanding between an invention and an innovation. Invention is always theoretical, always a mental exercise, always an intellectual exercise. That is the invention. Of course, you convert that invention into a patent document if you have to file a patent application. And then that patent application becomes part of the intellectual property that is there. That is all part of that one I we call invention, identification of the invention, for discussing what to do with it. And then filing a patent application is the important part of your inventive step. So once you have arrived and completed the invention, the next part, of course, is the innovation. Innovation means applying the invention in the practical space. Lot of people think of that ideas are marketable. In my experience, at least, the idea itself is never marketable. And the idea itself even does not create an intellectual property asset. It is not an asset. The idea converted to an invention may be an asset. I filed a patent application, the patent is granted. I would say that my 101st own patent application on what is called the Atma bot, a chat bot it was just granted a patent 3 days. It was allowed. No, I received the notice of allowance from the USPTO on the Atma bot. A very different kind of chat bot, and if anybody is interested, I can share that with you guys. That particular patent, that was my 101st patent that was granted in the patent realm space, my own invention. And because I get ideas of my own, I believe that I can fully understand sometimes the joy and ecstasy of invention and the frustration of an inventor when that invention cannot be fructified, cannot see the light of the day. So to that sense, although I very humbly say that I have a little expertise in this domain of intellectual property. I'm also an inventor in my own right, and I take pride in my inventions, and some of the inventions have been fairly successful in the marketplace, right? So ladies and gentlemen, there is a lot of hard work. This is where the body comes into it. This is where the other aspect, the physical aspect of the invention comes when you convert an invention into an innovation. The innovation is the practical conversion of your invention into a product or into a process. In India, there are 3 types. There are only 2 types of patentable inventions, which are called products and processes. Other types of inventions, there are a lot of other inventions, but other types of inventions are not patentable. They are still inventions in their own right, but not patentable, ladies and gentlemen. Therefore, that part is the important aspect to understand, that if I want to convert my invention into a marketable idea, I need to first convert it into an innovation. I need to see, or what we in engineering terms, we call it the proof of concept. The proof of concept is in the innovation, ladies and gentlemen, not in the invention. The invention is the concept. The invention is the concept. The proof of concept is the innovation. I mean, now with the computer generated world, we are now able to model. We are now able to try innovation by the process of modeling. I still feel that is not enough. In the finance space, in the market space, I need to convert my invention into a thing of beauty. I need to have an invention that not only looks good, feels good, is one of a kind, and I need to put as much of my energies, physical energies, the brain, the working of the brain, the working of all the senses into that innovation, and that is extremely important. A prototype, ladies and we call that in engineering terms, if it's an article, we call it a prototype. If it is a computer software, we call a beta version. We call it a beta version. If there are other aspects, we call them trial versions or trial aspects of various aspects. Various other names. They can go. They're all the same thing. They are the proof of concept. And that has to be extremely sound. And most of the unicorns who were created had a proper proof of concept. Ladies and gentlemen, they came to me. When they came to me, they had come with inventions. They came with ideas, some of them. We converted them into inventions, and those inventions were were then converted into a proper invention, which became an innovation, and then there is a market space. Only I would like to share, and I've taken permission of the person to share this with you. The largest, what are called all people who are connected to cooperative banks. The idea came from a small one individual who came to me about 16 years back with an idea for a payment system. And that idea, now of course it goes, if you can look at it, it's called Sarvatra. It is called the Sarvatra technology, which is used now for your for the payment switch, the payment interface switch for cooperative banks. It is a form of the payment setup or transfer or exchange, which is at a small scale level, but mainly in cooperative banks and at the farmer level. And that was, I would say, is one of my earliest, that I would say is one of the earliest unicorns that I handled. And I'm very proud that I was able to take that. Of course, the patent was refused in the first instance. I fought it out at the appellate board and got that patent, got it returned and got that patent granted. And then finally, of course, the invention succeeded. It became an innovation. It became a proper market strategy. And it is now, it is at that point of time. I have, of course, handled various other payment systems after that, including the one that is currently in India, the major one. I don't want to take the name of it because I don't have permission for that. So but that is also, I've steered it through and got them patents and got them established in India. As far as that is that aspect is concerned. But the innovation aspect, ladies and gentlemen, is probably the most important part of taking your idea to market. Of course, now if you are looking at finance, where people falter, where many startups falter, is because they underfinance themselves. And I'll come to that when we look at the biggest IP mistakes that many startups make. Is after I've just finished this particular of my 6I story, the next aspect of, after you have done your innovation, you have tested your concept. We call it proof of concept is ready. It is important you file your patent applications if the patent application is due. Now, at this point of time, the next I is investigation. I need to investigate what we call freedom to operate, freedom to practice, landscape searching. This is the point of time, ladies and gentlemen, when searching is an extremely important exercise, or investigation, I would call it investigation, is an important exercise. A lot of patent applications, or a lot of inventions, or a lot of ideas failed because they firstly did not file a patent application in time, and secondly, because they did not do a proper investigation to know what was out in the marketplace. After I've done my proof of concept, I must then do this aspect of investigation. Now, if you are going to go, if you will be wanting to look at finance, and most startups are looking at finance, whether it is angel funding or venture capital funding, or straight, sometimes even family funding. In family funding, it's not so important, but yet at least these questions will be asked of you. The investigation report we prepare, and I have the privilege of working on both sides of the fence. We work for lenders. We work for people who lend money to, or give money to startups, and I am proud to be associated with all those financials, and I'm proud to I feel very proud when a startup which I have nurtured up to a particular level gets proper funding. It gives me great pleasure for that aspect. But I have also worked for fund managers who have come to me and said, we need your separate opinion whether this idea is proper or not. Then we ask for the proof. We ask for the proof of concept. We ask for the investigation. We do the investigation sometimes ourselves, and then give a report. Sometimes very good ideas. There are good ideas, but then they've fallen because somewhere in China or somewhere in Korea or in the US or in Europe, there is a patent. There is already a patent, and that idea cannot go forward into an intellectual property. It cannot be protected because somebody else has covered that by a patent. So that investigation is very important, because if you move to the next stage, if they form the proof of concept stage, see, developing a proof of concept is not violation of an intellectual property. Research, intellectual property, or this whole IP space never prevents you from conducting research in respect of your intellectual or whatever idea that you had. So up to proof of concept stage, perfectly valid. You can develop your idea into this proof of concept stage. But after that, if you are really looking at doing or making things public, then you need to, and it's important that you apply the fifth I, which is investigation. All right. So I'll repeat these 5 I's at least up to this stage. Imagination, the space from which you get your ideas, the idea from which starts your business in the first place. Every business, every startup is started on some idea. All right. So then identifying the idea and giving it and seeing what is the inventiveness or what is the invention in that idea. Third I. Then of course the fourth I is the innovation, that is converting that idea or the concept into a proof of concept, or proving that concept, proving that idea that it really works, that it gives me what is called either a technical advantage or some economic significance. These are the words from the Patent Act of India. Any inventive step, any inventive idea must have these two. Either they must have an inventive, a technical advantage over something that was there, or there must be an economic significance. It must be financially worthwhile. Or then that is an idea that can be put into the market. All right. And the fifth I, ladies and gentlemen, is your investigation. All right. But there is still one more I. You've done all these successfully. You do all the 5 I's successfully. There is still a last I, ladies and gentlemen, and that is called integration. I have to integrate my product. I have to integrate my product into the market space. Unless my product has some value for the market, however successful the idea is as an idea, however successfully I may prove it, whatever investigate I may even, if I get my patents, I get all my patents, I protect all my intellectual property, I give it a good trademark. Trademark is also another good form. Many products have succeeded mainly because of a good trademark that was attached to that particular idea or the invention. So that integration is an extremely important, whether that idea can be integrated into the market space. Now integration, I'll just give you 2 examples of ideas that came my way, and we had even the proof of concept. The products was there, but could never be integrated into the market. The first idea was for a razor blade, a simple thing like a razor blade that could be sharpened. That could be sharpened and that could be taken forward, for example, and repeatedly that blade could be used even for 10 or 15 years. We got the patent, we got that blade, it was a coating process and the blade was almost like an everlasting blade. So it could be used again and again and again, and it could be resharpened, a razor blade. Now the guy, we got a patent, we got several patents for this guy, for this particular person. Proof of concept was there, idea was there, investigation was there, it was really unique, everything was there. But when it came to the marketplace, no blade company, and this guy, the person who got the idea, he tried to market the idea to every razor company in India and overseas. Nobody was prepared to take that because it could not be integrated into the market space. The reason is that once a person sells, once the company would have sold one blade, there would have been no other second sale. It could not be integrated into the marketplace because there was no market. There was no market for such an idea. The market needs obsolescence. The market needs a product to fail after a while for sustaining its business. Therefore, such a product can remain as a museum piece. It remained as in the Hall of Fame as a great invention, but no market. Another invention that came my way also suffered the same fate, and this was of an electric bulb. That was almost like permanent. It would never. The filament of the bulb would never blow up. So it was a permanent bulb. There was no wear and tear in the bulb. The bulb would light it. When it came, the guy had come to me with a concept where he had tried for an accelerated studies for almost 5 years of use, and the bulb was still as bright as it was on day one. The product also, this guy again tried, the patent was granted, everything was there, everything was finalized, proof of concept available. It could not be integrated into the market space, ladies and gentlemen, because there wasn't a market for it. And of course, some products were not successful because they were well before their time. I remember over 25 years ago, people came up with electric cars. The first electric car patent, or the first vehicle that could be sustained on solar batteries or normal batteries or whatever. People came to me over 25 years ago, where we tried to file patent applications. We got the patents granted. The guy was a guy from South India. We got the patents granted. Everything was there. He had his claim to fame on YouTube, and it was available. But there were no takers, because at that time the entire space was taken over by IC engines. Nobody wanted to touch. There wasn't a Tesla, or there weren't the other car manufacturers did not exist. And those ideas that were there at that point of time. So integration into the market space is the sixth and important I. You may do all the other I's properly. Looking into the market space and seeing that there really needs a level of experience for the inventor, for the startup person who puts his very, very hard-earned money and time and energy into an idea. There must be an integratable, something that can integrate into the market space. Extremely important, ladies and gentlemen. All right. Now I come to the second aspect is what has to be done. So once you have the proof of concept, the important thing is, of course, to file your patent applications. The basic thing is that sometimes if the patent application is very important. We have also in a few countries in the world, if we are in the ICT domain, a few countries in the world also offer what is called a registration of the copyright, of the code that goes into these into some of the software programs. I believe several of you are from the ICT space. Several of you are part of the Bitcoin and the blockchain technology world. Some of you are in the hardcore electronics. Some of you are hardcore software developers. Your ideas are in that space. There are a few countries in the world that offer protection of the copyright by way of a registration certificate. And these few notable countries that I can tell you are the US, India, Australia, and China. These 4 countries offer what is called registration of your code, and you can protect your code under the Copyright Act. Ladies and gentlemen, a very inexpensive form of IP protection is this copyright registration certificate. It has immense value when you are looking at finance. So coding, protecting your code, repeatedly protecting your code, every version of your code as copyright is an extremely important tool in a startup that is there in India in the ICT domain. Very important to protect that, though, the copyright registration, because when your software code or when your code is copied, or when that element, that copyright registration certificate is what the many courts are demanding. That do you have the copyright registration? Is your copyright registered in India? And only on that basis they will then enforce that IP right against people who are copying. All right. Now I come to a few last areas of my talk today. An important area of talk that I want to discuss is who is your or how do you protect, or what is the kind of protection that you need. I'm not talking about the ideas to market space. I'm not talking here, but what is the where is the area that you really need protection? Ladies and gentlemen, you first need protection from yourself. From yourself, when I say protection from yourself, I mean the people you are working with. Unfortunately, during the pandemic and in the last 3 or 4 years, our major areas of litigation where people came to me with their sad stories were when their own either employees or partners or people working with them or people whom they had given things for developing, these are the people who stole their idea. So a proper non-disclosure agreement, proper agreements don't leave this aspect to fate. We are in a very materialistic world. And in this world, what works is only a proper a suite of agreements with your employees, with your partners, with your developers, with your vendors, with your sales team, with people who are developing things for you. This suite of agreements, you have done all your patent right, you have done all your invention right, everything is done, you have done your proof of concept, but it is very important to chalk out who does what, organize yourself in a proper set of agreements, and don't delay this aspect. Many startups have failed because they postponed. I believe that the worst mistakes that startups do is feel that is a universal mistake, is that they feel small. A startup feels that it is a small entity. Who is going to copy my idea? Why should, I mean, I'm such a small entity, I'm such a small player. My idea is still an idea. I don't have the money to put into this idea space. I don't have I'd rather put it into some other areas of my development. Now, this, ladies and gentlemen, is the primary mistake, is to think small. Think that you are a startup. You have to plan for becoming a unicorn. You must have the vision that whatever idea that I have, of course, discuss with your mentors, discuss with people like us in confidence, discuss with MeitY, discuss with the Center of Excellence, this particular program. Discuss with somebody after you filed a patent application. How do I take these forward? There are schemes available to you. There are other areas available to you. But having a proper set of agreements with your people, with your own people, because there is a saying, and this is Confucius, I'm quoting Confucius here. Lord, forgive me. Lord, protect me from my friends and relatives. I will put here all my business partners and associates, and in that. Lord, protect me. I need Lord's protection. My enemies, I will take care of them myself. That is an important thought process. If this is the other share, that please do not procrastinate or do not delay. Firstly, have the vision of a Microsoft. Have a vision. Apple or Microsoft or Google or Amazon did not become what they are today without having a vision. They all started. They all started small. They all started with an idea. Whether it is Dell, whether it's any of these guys, they all started with an idea, and they never had that luxury. But what they did was they protected their idea. They had their proof of concept ready, and they filed their patent applications, and they're continuing to do so. Whether it is Qualcomm or whether it is some of the Chinese companies like Huawei and Tencent and ZTE or Ericsson or any of these guys, any of these companies that were there, they had a vision. The person who started these companies, or whether it is Tesla at this side, or whether it is Virgin on the other side, all these people started with an idea, and then they had a vision that they would make it big. Look at Baiju, for example. Baiju started with such a simple idea. Oyo started with such a simple idea. All these guys started with very simple, basic ideas. But they had a vision that I will tomorrow become somebody at some level of activity. And this never, ladies and gentlemen, happens by accident. It happens by coincidences. It happens by high levels of energy. It happens by vibrating yourself in unison with the spirit or the spiritual world. It happens with that. And also at that point of time, it happens that you curb your fears. You curb the fear. The greatest fear that you have is, am I worthy of this idea? Am I worthy of this creativity? Am I creative enough? Or who am I? Will I succeed or not? And because of this fear, people don't just take off. They are stuck where they are because they don't take off. And that is the biggest mistake that a startup can do in this idea or intellectual property space. There are a few others. For example, thinking that I'm going to go a global level, with forgetting to consult and people who would tell you that basically there is this whole territoriality of invention. It means a patent application is a patent application only in the territories it is filed. Indian patent, for example, cannot be exercised or cannot be, does not enjoy any protection in the United States, or it does not have any protection in Japan or Korea, or a Korean patent or the US patent does not have a protection in India. People forget this elementary aspect and delay until it is too late. The first mistake that they do is that they publish this idea before even protecting the idea. The second mistake that they do is that they underprotect and they think small, and they procrastinate as far as before the problem goes totally out of hand. So, ladies and gentlemen, that is the IP. That is for my thought for today. Is I am sharing this so that you and your or people connected to you do not fall into the same error. It was Mr. Mashalkar who made this comment, and I'm borrowing these words from him. You publish and perish. In India, there is a culture of publication, of disclosure of ideas. We need to, and it is part of our educational system, part of the educational system of our country, where I counted on last time that in every year over 500,000 good ideas are lost as part of our PhD and educational programs, because they became part of the PhD thesis and were published as papers, and people rush to publish these ideas into journals, because that is what our educational system taught them. Lord Macaulay's educational legacy that taught us to publish our ideas before patenting them. So Mashalkar's first part of his statement was, if you publish, you perish. And the second part was, you patent, publish, and prosper. So if this is the thought process that I would like to leave behind with you, that important thing is that if there is a patentable invention lying out there, you need to protect that patent application. You need to protect your idea. You need to protect your proof of concept, even before you reach the proof of concept stage, by a proper patent application, because that is what we are your friends. We as IP attorneys are your friends and will give you, as I believe most IP attorneys in this country or anywhere in the world will give you that kind of right advice. Don't have that inferiority complex that I'm a startup. How can I'm small. The first thing that when many of these startups come to me is that I'm a startup. Please treat me like a startup. The government of India is also treating me like a startup and has lowered the fees for filing of this patent application and has given us those incentives. So what that happens is that it develops an inferiority complex in the mind of that individual who is now running a startup and say, I don't have the funds. I am a small person. I do not need to protect my intellectual property to that extent, or as far as the way it is there. Who is going to copy? All those kind of thoughts come, those kind of fears that come into their mind. So that is the first thing my sort of blessing to them is that please don't think I want to look at your invention as Eureka. This is Eureka. This is what Archimedes, you are an inventor. You have come here with an idea, you have come, and I want to respect you. By you yourself demeaning yourself and say that please charge me low, have mercy on me, treat me as a startup, which even when you go to the government and you ask these kind of things, I would like you to throw yourselves open that you are a visionary. You are not a startup, you are a visionary. You need to be treated with respect as a visionary. And with that vision, take your step forward. Take your step with pride. Take your step and don't have that inferiority complex that I am a startup. Unfortunately, that startup has become a word for being somebody who is poor with good with ideas, but low on the pocket. Yes, that may be true at the moment, but that is not to answer any of your queries. Any of your queries anybody may have, I'd be glad to answer them. Yes. Yes, sir. Mr.
Please carry on with you.
Yes, sir. Mr. A.K. Roy.
Anyone asking, please ask questions.
All right, sir. If there are no questions, and they can send me offline. Please share my presentation. Please share my email ID. If they are a little shy.
I think, sir, there is a question from some network. I mean, there is some problem.
All right, sir. Sir, they can ask the questions offline. I'm be quite happy to share it with you, and the answers. I'm quite happy to put it onto your platform, Mr. Roy. Dr. Roy, I can.
Okay, everything so succinctly. There is currently no questions. There would
Hello.
take some time to absorb the idea. Yeah, I think there is a question. Yeah.
Hello.
Yes, sir.
Yeah. Thank you, sir. Thank you for providing us this opportunity. Sir, I have one query regarding IPR. If I am using some other technology companies, say for example, I am taking Intel's technology to design my own architecture or own design. So is it eligible for IPR?
Of course it is. See, most ideas are built on other people's ideas.
So I think I have missed the bus, because I have an idea and I published that idea in National Startup Challenge, and in that idea, but I approached to NRDC, National Research Development Corporation. I have approached to them and I have shown them that this is my idea. So please do patent, because we are a startup firm. So please do patent it. But they said, no, it is not an good patent. It will be not they use some term. I am just forgetting this. What I have done, I have used Intel's microprocessor architecture technology to design my hardware. A hybrid hardware. I have an idea, a hybrid hardware startup. So still date, and post that 3-4 months back, just now Gigabyte has launched this type of device in India.
I'm sorry, sir, that that the bus sometimes when the bus leaves, and I feel very, very sad. So I feel
yes, I'm very sad, because I was not able to do that IPR.
And I have absolute compassion for you, sir. But there is always a next time, and I'm sure if you have got one idea,
I have another. I can tweak that, but how to reach the IPR? Because IPR is a very costly, and everything is.
Nice, sir. Please don't look at it in the cost terms. It is not really a costly exercise, because it's an important exercise, and that is the only aspect where you can leap forward.
So how can I reach, sir?
Sir, so you maybe okay. I don't know where you are located, sir.
I am located in Noida. My name is Sujan Dev, and my startup name is Antrix Networks. So
yes, I can see your idea. There are good attorneys. There are see, NRDC is of course just one facilitator, and they are good facilitators.
Yes.
And there may have been some reason for them to tell you. They may have had some reason.
Because it was a completely technical documentation, and it was very high for them to understand what I am suggesting to tell them. So they
maybe, sir. Maybe.
What they said, I think it might not be a good IPR, or some terms are there.
Yes, sir. Sir, what I can say is that there was another area, for example, there is another very unused technology. If you have done a hybrid circuit,
Yeah.
it is called ICT. Dr.
Yes.
Garg is a really a specialist.
It's in ICT. It's in ICT only.
Yes, I know, sir. So because it's an ICT, in fact, there is the topography of that circuit.
Yes.
Could have been protected as even if you had not protected as a patent application.
Still,
you
the
could have
topography is there with me.
Yes, sir. The topography, and if you have disclosed the topography, and if you have not disclosed it, then it can be. I mean, MeitY is the organization where that these topographies will be protected, and I'm sure you speak to somebody in Delhi, some good attorney who will tell them about you want to protect this as an integrated circuit design, as a topography of that design, and they will be able to protect it. They will be able to help you to protect it, and it is a good right.
Even I have already published in National Startup Challenge.
Sir, unfortunately, if it is published, then you will have to wait for the next idea, sir.
Yeah, already we are waiting for the challenge answer. Still, we are waiting for the result.
But you have to wait for the next idea. When the next idea comes, meet for some family member of the IP attorney group.
Okay.
Pay him a small consultation fee. The consultation fee is very little, and get that idea. And
Okay.
of course, you did go to the NRDC, but I believe that that there were other groups of people who could have helped you. For example, in Delhi, I know of an organization called TIFAC, TIFAC.
Okay.
TIFAC is somebody who may be able to help you in that space. Even MeitY, they have a cell where they help people of your ilk, or go to an attorney's office in Delhi. We of course have our office, but I cannot tell you that you should come to our office. There are good attorneys all around the place. Look at a good attorney who has got a background in this space.
Okay. Thank you, sir. Thank you.
You're
Thank you
welcome.
for your answer, sir.
You're welcome.
Sir, I have another question. I'm
Yes,
Dr.
Dr.
Mandeep from CDEC Mohali, sir. Sir, thanks for giving me the opportunity, sir. Sir, my question is, suppose I have built some technology and I have already transferred the technology to my client, and can I patent that technology, or still the copyrights of that technology are with my client?
Like Mandeep ji, I mean, it all depends upon the agreement between you and your client.
Okay, sir.
If the client will allow you and will acknowledge you as an inventor,
Yes, sir.
then we can have a patent application in the name of the client. But hopefully, the client has not disclosed that technology beyond them.
Jointly, we can file the patent for that, sir?
Yes, I believe Mandeep ji, we can file if it is not disclosed. If it is still between you and the client, then the client can file the patent application designating you as the inventor, and the copyright application can be filed for the code again in your client's name. If you have received money, then it becomes what is called in copyright language a work for hire. The client hired you to do some work. You can be qualified as the inventor and take it forward and protect that invention.
Okay, sir. Another question is very simple question is, suppose I have built some X product,
yes,
and same kind of products are available in the market. They are giving the same output, but the circuitry, the design, the software, it is developed by me. It's my own propriety. Can that also be patentable, sir?
Yes, sir. What we'll have to do is, as that is the fifth I called investigation, sir.
Okay.
We will need to investigate to find whether that you have already developed, you have tested it, you have found that it works.
Yeah.
Now to protect the IP, we of course need to first file a patent application.
Okay,
And
sir.
then to see whether it is going to be granted, we need to go through the investigation process to see how different your process is and what is the technical advantage. Is your product cheaper or less expensive, works faster, works with less number of elements,
Okay,
whether there is some technical advantage in your process, then you get the patent.
Okay, sir. Thank you so much
You're welcome. You're welcome, Mandeep. All right. Okay, sir. Dr. Roy?
Hi, sir. There is one question. So there, it was asked, can we patent workflow like in data processing,
Yes,
data
sir.
delivery?
Yes, sir. Yes, sir. Workflow, I have patented for TCS, for Tata Consultancy Services. I have got 5 or 6 patents for different types of workflow. We can, it all depends upon how you look at it. We have to convert it into a system. We have to convert it into a system. And it is possible to do that.
Okay. Send to my mail.
Another question is on chemical structure.
No, it's okay. Whatever is there, you send to mail me. Send. We'll see tomorrow.
Okay. Okay. Right, Parimal?
Please mute yourself.
Yes, sir.
Can I request everybody to mute their mic, please? Thank you.
Thanks very much.
Yeah, sir, there is another question on chemical structures. It
Yes.
says, if an exact chemical structure does not show up in the course of a scientific search, then
Yes.
will it pass the prior art search?
No, will it have a prior art search? Is that I'm not sure about the question. See, there is a
May I
cache
repeat
number.
the question? Because
Yes, Subhadeep.
yeah.
Yes,
So
please.
what I was asking was, so SciFinder is the database of chemistry,
Yes,
organic
Yes, sir.
compounds. So let's say I create a compound and I want to check it through SciFinder whether somebody else has it. You find out that it does not exist either in the chemistry literature or in the patent literature.
Yes.
So what would be the status of that when you go for a prior art search before trying to file IP?
You, as Subhadeep, in a case like this, which means obviously if it is not found in SciFinder, if it is not found in chemical abstracts, there is no cache number for this structure, right?
That is correct.
There is no cache number. If there is no cache number for the structure, the first thing that you should do is rush to the patent office and file a provisional patent application in India.
Many thanks.
You can file a patent and thereafter then do any other searching or then do the disclosure of the compound. Then there may be a Marcus structure, converted into a Marcus structure where you have R1s and O1s and X1s and Y1s, convert that structure into its structure, and then take it up for trial, Shubhadeep.
Many thanks.
You're welcome, Shubhadeep. Right, guys? Parimal?
Anil, let's take a last question. So there's one question from Sonal.
Yes.
She asked, like, what should we do if someone from overseas infringes the IP?
Yeah, if somebody from overseas infringes the IP overseas, then that is exactly the tragedy that I'm talking about. Because if you have filed a patent and got a patent in India, and somebody copies that particular product in Germany or in the US or in the UK, and you have not covered that territory, then of course that the IP in India is only bound by the territory. So if somebody overseas, unless that person sells that product in India, you have no rights in that IP in that country. Parimal?
Yes, sir. Thank you very much.
Sir, last one question, sir, from my side.
Yes, sir.
Sir, so if we need to file patent, how many countries do we need to file patent? Like in computer? Yes.
Yeah, you need to file the patent application first in India. The law requires you to first file the patent application in India. You have then 12 months. You have a full year to decide in which other countries to file. If you file another creature called a PCT application, you can buy another 18 months. First 12 months is free. So really, file your patent application as soon as possible. You have almost 30 months, 2.5 years to decide and go. I tell people that if you're not able to convert your invention into proof of concept in 2.5 years time, forget about it. It is a good idea, but not a practical idea because you have not been able to do it. So move on to some other idea as soon as possible.
Thank you, sir. Thank you, sir.
Sir, Dr. Roy, I hope you can share this presentation and my ID with all the participants. And they can write to me if they want offline. And whatever questions and answers I will put it onto your platform so that you can know it will be part.
Thank you, Dr. Diwan, for the illuminating session.
Can we get sir's email ID?
Yes, sir. I think all the participants will get it, sir.
We'll facilitate. All the participants, please stay rest assured that we'll exchange Dr. Diwan's email ID.
And if you can, all of you can share on LinkedIn, because on LinkedIn we publish articles almost every day. So if you can connect with me on LinkedIn, on my LinkedIn page, on LinkedIn, we would be able to share all new developments, including the 2 new developments. For example, in Europe today, an artificial intelligence patent has been granted to an invention by an artificial intelligence, and in India, a copyright registration has been given to a computer-generated image, a photograph that was created by or a painting that was created by a computer. So that is now. So we are now in a totally different realm in the ICT space. All right. With these words, I think I'd like to close, Dr. Roy.
Yes, sir. Thank you, Dr. Diwan, for your very illuminating session. I would now request Parimal Khade, Project Manager, CoE-IP, CDAC Pune, to propose the vote of thanks.
Thank you, Anil. And as of now, all of us must have known that that for any tech startup or even for the tech organizations to have IPR is far more important. I just wanted to say one thing. In this background of a new wave of digitization and automation, which is rapidly altering the economics around the world, and the various innovations are leading the activities are making the way towards a new tech life. And to support this, CoE-IP is providing various services to the startup. I mean, we just heard one of our friend participants from Noida who felt that we have missed the bus. But I think to help all this such kind of a startup, the innovators, the CoE-IP, which is running at MeitY Delhi and even for that matter in Pune, is there to support, to help you out in your journey from your idea to commercialization. So Diwan sir, actually, it was so nice